disclaimer. I have to give a disclaimer. This is not legal advice. This is more educational, and this does not create an attorney-client relationship. And there is the fine print. Let me give you a brief history of my background. I worked with Rio Leslie over the years. My history goes back 40 years with DORA. I started in the 80s, and what happened was I was part of the reorganization of DORA with Amos Martinez when he was program director, and Rio and Larry Palmer back in the late 80s or early 90s when we restructured DORA to a great extent. So we represent mental health professionals, and I've been quite involved. Rio has been in contact for years and has wanted us to get more involved with you. He's basically retired now. I'm not retiring. I'm going to go out feet first, probably, that kind of thing. And my doctor tells me that if I did retire and go home, I would drive my wife nuts. So I'm staying here. But anyway, we handle DORA grievances, all that stuff, mental health professionals. We handle, should you get grieved, we will handle that. We handle your business startups, and the forms you need for practice, so disclosure statements, all that. And we handle subpoenas. If you are subpoenaed to testify in court, we handle that as well. And that's where we were this morning, were a bunch of subpoenas, and everything went over. My history is, I've been practicing since 1977. I was with the Department of Justice for 7 years. I formed this law firm in 1983. I'm a former district attorney, but I've been doing mental health stuff for 40 years. That's the history that I've got. All we do is mental health work. So that's where we are. Now, we're the council for a number of professional groups, but I've seen the evolution of CAP through the years, and I've been familiar from a bit of a distance. We were more involved in the 80s and 90s before the LPCs were all brought in, and that was what Amos and Larry Palmer on the psychotherapy board decided to do back in the late 80s, early 90s. I was the unofficial legal advisor to the psychotherapy board because they liked my guidance more than the AGs, the attorney generals, because we knew what we were doing. So they really liked that. Through the years, we've had a lot of clients, and I run about, I had 9,000 clients last year, and we run this, and so we go. And I have a team of paralegals. I have 9 paralegals. And if you go to our website, you'll see all that. And that is Robert A. Lees, Lees as in Sam.com. Now, my history goes back quite a ways, and I've seen the whole change of things and in the future. And we talk to DORA probably once or twice per day. So we are, we're involved quite a lot. And I want to put on a CEU seminar. NBCC has said to me that they want to work with us. Ryan Hockel over there, because I've spoken at their national conferences. But we do a lot of teaching and a lot of stuff. And so I thought I would link up with you because I know Rio has pretty much phased out and that kind of thing. So we do therapist defense. We do not do any plaintiff's work. If someone, we will do your defense. We will not represent any client against you. We will not represent any therapist against you. That's not going to happen. We do that. So we have monthly questions and answers, which are welcome to join. And we do that every month. And we have a newsletter that we're supposed to get out monthly, and we're behind the curve on that. But we will be getting that out. What I wanted to talk about today, that's a brief encapsulated history. You can go to the website for more. And again, that's www.robertalees.com. And you can do that. Now, What we did around here was the fact, I helped draft on the Child Abuse Protection Statute back in 1993, and I testified on it. And we have updated our child abuse protection packet. And it's an outstanding packet. It goes into what you have to do as a mandated reporter, which you all are. It goes into elder abuse and how to report that, and how to report your clients when they are imminent risk to themselves or others. You are welcome to get that packet from us. It is valuable. I ask that you do not reproduce it and share it around, because it is our work product. It's worth several $1,000s. I'm offering this to you because I want you to have it. Now, what we do around here a lot is to correct disclosure statements that, because that's your primary defense to DORA. The rule is, if you disclose it, you can do it, so long as it doesn't violate the law. You can do therapy any way you want to do it, provided it doesn't violate the law. And that's an obvious tort, such as engaging in sex with a client or whatever, that kind of thing. But you can practice therapy as you want, in that sense. Now, you were targeted by the social workers, went after your group a lot. They're behind a lot of the legislative changes. I know the politics behind it. They were quite active, and they targeted you. The social workers really, the Colorado Association of the NASW really made you a point. I said to them, back off, which they didn't listen to at all, because I said, we have some very good psychotherapists and people very well qualified. And why are you so obsessed with them? Well, they were. And that's why your regulations and your licensing has changed back and forth so much. It's the social workers. Their lobby is really very strong. And they, of course, when you became registered psychotherapist a couple of years ago, the social workers did a strong objection to that, and went after you for that. And they insisted on you be called unlicensed psychotherapists. That's where that came from. Now, Rio did his best to block a lot of that, and your staff did, but it didn't work much, because the social work lobby is very strong, and that's what they did. So what we saw in the late 80s and the 90s was a future transition. This was driven by the psychotherapy board back then, which Larry Palmer was the chair of. Amos was the program director for 18 years. Amos came here for his second retirement for 5 years with my firm. But we saw the rise of the LPCs come in. And that was brought in from Georgia, which was Larry Palmer's home state. That's where all that came from. So that's how it wound its way here. And that's what you're all caught up in, is that group. And I know, and I've been involved, we represent a lot of LPCs and a lot of psychotherapists. And so we know the history there quite a lot. On the child abuse side of things, the report is outstanding, and or the directions we have for you. And I want to highlight just a few things, and we'll talk about DORA real quick. And again, I apologize for the rush behavior today, because we're not going to hit everything due to what happened this morning. But anyway, what we do is we outline signs of abuse that you need to be looking for, that kind of thing, how to report, on the numbers to call. There are 5 categories in Colorado of abuse, and the big question is marijuana today. Where does that fit? If the parents use marijuana, or there's marijuana in the house, is that child abuse or not? The American Pediatric Association says yes. The AMA is still thinking about it. but it's something that, that's an open question. And in the state, now we've gone to, on a magic mushrooms. And so the question is, what role is that gonna have? So I see my job for you, if you want this, is to really help you guide your practices so we keep you safe. That's the goal. And so it's because I want you to practice our job over here, what I get joy out of and why I love to do what I'm doing. And that is the fact my staff is thoroughly into this. We really like this. Our job is to take the burden off of you to stay current from a lot of stuff. And so that you can consult with us. All law firms are required to have a retainer and a fee agreement with their clients. So what we've done with that is we have a fee agreement which says what our rate is. We have that. And then for the retainer, we reduced it down to $495 per year rather than $2,000. We went to $495, and we give you privileges with that. And the privileges are with that is the fact that you can call us at least twice a month. I frankly don't keep track. If you're in a tough situation, I want to hear from you, or my staff does. And I monitor the phone. I've been doing this for over 40 years. I get up. When I was a DA, I covered 5 counties. I had 16 law enforcement agencies. I was on call 24/7. And my poor wife has had to live with that. And that's just the way things are. So you can call 24/7 if you're part of our group, and then we will, I will get back to you. If you say, Bob, call me now, I will call you whenever I get it, whenever now is. If you say, Bob, call me during regular business hours, I'm gonna call you then. But when I need to travel through the state, I travel at the nighttime. And when I get cell phone coverage, and if I've got you, and you call my cell phone, or it's transferred to my cell phone, I will call you whenever now is, whenever I get a reception. But if you say, call me during normal business hours, we'll do that. But if you get into trouble, and if you're nervous about something, you call. I had a dear therapist who called me several nights in a row at 4:30 in the morning, and I said, you know, you got to kind of think this out a little bit. But before you call a bunch of nights in a row, because I've got to sleep sometime. But anyway, I want to hear from you, and that's my job, and and we take that seriously here. So that's we are here to protect you. And this is, I'm going to be straight up front with you. If you are grieved by an agreement and you turn it over to us, and you always should turn it over to someone you trust, someone competent, well, what will happen is our success rate exceeds a 95% dismissal rate. We get 95%, I think it's 98%, but I can't calculate it beyond 95%. I can't mathematically do it. We get grievances dismissed on the intake over 95% of the time. If we don't get it done going in, it goes to expedited settlement. Your board will come back and will refer any questionable thing to expedited settlement. And then they try to negotiate a stipulation with you. And if that falls apart, it gets referred to the Attorney General, and they assign somebody, and they've just had a bit of a staffing change. But they assign an AG to you. We know them all. We professionally respect one another, and we're courteous, and we present the best appearance that we can to them, but we are not their friends. This is something we are here for you. Now, Amos Martinez, when he was program director, and I became very, very close friends. and we do things with our families together. That benefited everybody. And that was really beneficial for our people. When Amos, in the 80s and 90s, I would get 3 or 4 grievances per month when Amos ran it. A couple of months ago, we had 41 grievances in 1 month. And we're averaging between 30 and 40 per month. DORA has changed, and I don't want to give you all PTSD here. So tell me if this is too much, but DORA has changed, and DORA has said, we protect the consumer. They are not your friends. So DORA will not protect you. What we don't, well, I've been on 2 boards, and the psychotherapy board informally, but the LVC board, I was appointed to that. The idea is the fact that we used to get grievance responses from our therapists who wanted to share their heart, and they'd get into like 27 pages. And the deal is the fact the board would sit there and say, oh, well, we didn't know the therapist did this too. So don't do your own response to these things, but get somebody objective that you trust. It doesn't have to be us, but get somebody who knows what they're doing, that kind of thing. Now, let's talk about insurance briefly, and then we'll go back to how the grievance process works. If you have HPSO coverage, HPSO gives you free insurance while you're being trained or at school, whatever. However, once you practice, they make you pay the law firm first. And so in my mind, you don't need that stress, but they make you pay the law firm first out of pocket. They can take up to 3 years to reimburse you. I've had to go after HPSO several times, and we are their go-to counsel in the state. We're their panel counsel. But I've had to go after them 3 times to get my people paid. Now, they've been investigated 4 times by the insurance commissioner for Colorado. And CNA used to be the underwriter. HPSO is simply the agency that funnels the claim to the money people, who is the underwriter. And CNA dropped them. So HPSO has not had a good ride. I'd like you with a better insurance carrier, because this is stuff you've got to be careful about, because you don't need, in addition to any grievance, and today grievances are, as you know, are off the chart. This is what we've accomplished in the last year. If you testify in court and under order by a judge, and you typically will be called to testify in a highly conflict custody proceeding, that's very dangerous for you. There are guardrails. We file, when you're subpoenaed, we file what's called a motion to quash and a motion for protective orders. It's not a motion to squash, but a motion to quash. We file this, and that gives the judge boundaries, and we limit your testimony according to DORA rules. And we've got you protected by HIPAA, by DORA, and then by the court. And we get you under court order. We win 100% of those. The judges bend over backwards to protect your status as a competent therapist. They do that. The judges don't want to see you hurt, because if you get up on the stand and you testify, you're going to tick somebody off, and they're going to file a grievance on you. And that's what happens. The other problem, and we have successfully limited DORA's jurisdiction. For a while, DORA claimed there was a Chief Justice directive that came out while I was on the LPC board back in 2009. And DORA grabbed all over it, and the Chief Justice directive for the first time, this is from the Supreme Court to all courts, the Chief Justice directive for the first time granted DORA concurrent or equal jurisdiction with the courts. I dealt with that with the Chief Justice and contacted him and said, you've just opened up a huge mess here. Because now we're gonna have court sanctions or court issues with our therapists as well as DORA. But in the last few years, we've gotten DORA to back down completely. If we get a court order protecting you where you have to testify, and we get the proper releases, because you're all under HIPAA, as well as the state of Colorado, for releases, we get the proper things for you. And a caveat, don't ever do a letter for a lawyer. Don't ever do that. That letter is hearsay, and that's an invitation to be subpoenaed. The judge will not let that letter in by itself. You're going to have to show up for testimony, and that gets dangerous. What you can do, and I want you to treat both parents or guardians equally. What you can do is to do a treatment summary, and I would recommend that. And I would offer that to these people every quarter, sometimes every month if it's a high risk situation, but a treatment summary so you don't have to turn over all your session notes. The big hot button in DORA today is the failure to take proper note keeping. That's their big deal. And they always throw that in any charge that they make. So they always throw in that our therapist has not kept proper notes, and therefore they will issue a letter of admonition. Now, what happens, going back to the grievance process, I'm moving pretty quick here. And if you have questions in a moment, let me know. What happens in the grievance process is if we go in and we get a dismissal for you, you're free and clear. You don't have to report that to your insurance company. You don't have to report that to DORA. You are free to practice. Your record is entirely clear. If you get a confidential letter of concern, that's like a warning out of the board that says, be more careful next time. But we're not going to find any wrongdoing. That works as a dismissal. That stays in the DORA file for 5 years, and if you do the same thing again, DORA can theoretically raise that issue back, but in 40 years, I've never seen them do it. So, a confidential letter of concern doesn't go public, doesn't go anywhere else. When we file a response, any grievance you do, you're subject to, the complainant does not get a copy. They get a copy half the time because DORA misses a lot. And if you've ever tried to call DORA for answers to questions with their staff turnover, good luck there. But anyway, half the time DORA will say to the complainant, we've dismissed the case, but thank you for participating, kind of thing. They will do that. So a dismissal or an LOC, letter of concern, you don't have to do anything with. You don't have to go in the National Practitioners Data Bank. You don't have to go to your insurance company. You don't have to do anything of the sort. DORA can come back and issue what's called a letter of admonition and say, we admonish you for not practicing according to unreasonable standards. And they can do that. The letter of admonition is a permanent black mark on your record and lasts forever. We have lobbied DORA to put a time limit of 3 to 5 years on this. They had agreed to 5 years, then they backed away from that, and they said you're going to need a legislative fix. And so we have to go for the legislature for it. But a letter of admonition, DORA considers to be their lowest sanction imaginable, and they admonish people a lot. Now we go back to them and we say, well, you've just hurt our therapist with insurance and their practice and all that stuff. And there it is on the DORA website and LOA. From there, it can go to probation. And then you can get caught up in peer assistance. If the board has a problem with what you've done and it doesn't know what to do, I'm telling you the scoop on this stuff, the way these boards work is that they will send you to peer assistance. Peer assistance or peer, PAS, is a vendor for the state of Colorado. They're trying to act like part of DORA, but they're not. They're a vendor. And so they operate by contract with DORA. We have a lot of problems with peer. And we've tried to, I've had them on the witness stand a number of times, and I've tried over 1,400 cases and I stopped counting. But anyway, the thing is the fact that we've tried to really rein in peer, because once they get involved in your life, you're under a peer contract, and they're going to send you for evaluation and Pro B course, which costs $3,000, and all kinds of things. So we want to keep you out of that, but it's very difficult because a fallback position for the boards is to send you to peer. Beyond that, it can go to revocation, where they take your license or your right to practice for you guys. They would ban you for practicing. You would get a cease and desist, and then that kind of thing. But that's pretty serious stuff. Our approach is to deal with, if it gets to expedited settlement, and we have not knocked it out, our job is to negotiate with expedited settlement, which works probably 3/4 of the time, but not always. That kind of thing. We go to expedited and we try to negotiate a reasonable settlement, which nobody likes, but it works to get you out of the system. So anyway, if it doesn't work there, we lose the expedited settlement, and Attorney General is assigned to your case, and a notice of charges is then filed. That can or may not be public. DORA is not supposed to put that on their website, but they do from time to time. And the notice of charges will always have record keeping. We've done 180 degrees in this firm over the last several years about record keeping, because we used to have the view that less is better. Now we have the view that you've got to do more. And in my world of the Colorado Supreme Court, I've got to document every conversation I do with an email. They don't trust phone calls in the least. I've got to document things by email. Now we have a special presentation, if you all want it, that will go into how to do proper note taking and how to do all this stuff. Because we'll walk you through all of that. And then so your notes will be good. You can't cut and paste stuff because they'll catch it and that kind of thing. And DORA has the power to subpoena you. If someone grieves you, the privilege is off. And they have the power to subpoena your records, and they can do that. That's by statute. The boards are deemed to be a quasi-judicial entity. Peer is not. Peer is a vendor. But quasi-judicial means that your board, psychotherapy board, has the power to investigate, the power to discipline with immunity. I tried to sue the OPC board back in the 2000s when we won a case before the administrative law judge. Because what happens when a notice of charges is filed, it goes to the ALJ, the administrative law judge for everybody, every professional, it goes there. And in Colorado, the administrative law judge issues an initial decision, not a final one. I argued in the 80s we had to have a final decision from the ALJ. but they issue an initial decision, which in turn is not binding on the board. It's an advisory decision. This is crazy. Colorado is the only state that does that. In the other states that we deal with from time to time, by permission, I'm licensed in Colorado, but I do ask for permission for other states. Anyway, in the other states, any grievance filed against you goes to your professional association, which in turn mediates it. And then what happens is less than 5% go to that state's DORA. But in Colorado, they're taking anonymous grievances, which is ridiculous. And we've argued, and we're going to go to trial on this at some point, that anonymous grievances are a violation of your Sixth Amendment right of a confrontation, because you can't confront the person accusing you. You know, if you make an educated guess as to who the complainant is, you all know, without me saying, how dangerous that can be. But what we do is we really try to, you got to be careful with this stuff. But on anonymous grievances, the good news is we win nearly 100% of those, because we put up the defense that it violates your Sixth Amendment right under the U.S. Constitution and Colorado's Constitution, which has a parallel right. So that protects you. This constitutional argument is pretty good. And we see at DORA, why, first of all, and I said to them, why in the world do you, do you allow anonymous grievances? Now, in this firm, and I think your other lawyers are probably a part of this in years past, but in this firm, we're invited to private stakeholder meetings with DORA, which we go to. We're also in the pipeline for all decisions of DORA. These are often not published, but we hear what the various boards are doing. So what we'll do is, and your board is a board that used to be one of the heavy hitting, highly enforcement boards. It's not that way anymore. Your board has become more reasonable. But the LPC board had then moved to the LPC board to be the real enforcement board. Now, when I was on the LPC board, there were 7 members. You had 4 civilians and 3 professionals. It's now changed to 4 professionals and 3 civilian. Well, I'm a former district attorney, so I'm kind of right of center anyway. I was viewed as the left liberal progressive, which tells you how right-wing the board went off to. And I would say, let's give our therapists a chance. Let's tell them ahead of time what they need to do to be compliant. The response was, we educate by discipline. I said, that's terrible. Now, I have probably given you all a mild heart attack, and I apologize for that. And do you have any questions over what we've talked about so far? You're all sitting there in stunned silence, and I'm so sorry, but I gotta tell you what's going on with this stuff. And the history, this is why all this has really progressed the way that it has.
You know,
So,
one thing that might be helpful about is if you could, like, because you're giving some acronyms I'm not familiar with, so I'm not familiar with HBSO insurance or some of those terms. So maybe you can help define what those things are so that we have a better sense. I mean, maybe other people know what they are, I just don't know. But when we're looking at some of those organizations that you were discussing, I'm just not familiar with that that particular acronym.
Sorry to go so fast, guys. HBSO stands for Healthcare Provider Services Organization. They're a common insurance company that a lot of psychotherapists use.
Gotcha.
We don't like them because they make you pay your legal fees all up front, and that's by your contract with them. And in this jurisdiction, the Colorado and the 10th Circuit Court of Appeals, the federal 10th Circuit, has not been friendly to you on insurance companies. It views insurance companies as really contracts and says it's a contract. So the covenant of a good faith and fair dealing we used to deal with insurance companies, you got to be fair to the insured. The 10th Circuit throughout. And so HPSO and other insurance companies deal by contract. I want you to look at Philadelphia, CPH Philadelphia, Allied World, Profura has come in Colorado. They're really good. What other acronyms am I using that's throwing you?
That was the one that stood out to me. Did you guys have anything else that was standing out to you?
Not acronyms, and I'm glad CPH is on your good list.
We're panel approved for all the carriers, but I like CPH the best, Philadelphia the very, very best, because they pay your fees. What happens is we live by the panel rate, and we bill them directly, and they pick your case up right from the chute, and we get a phone call, and we get your information. And this is the deal. If we get any complaint dismissed, your insurance premiums will not increase. If we handle a subpoena for you, that does not affect your insurance premiums. There's nothing negative there. And with CPH Philadelphia or Allied, you can turn it over to them and they pay us directly, and you don't have to worry about it. You don't have to pay a retainer. We have to send you a fee agreement always by law. We have to do, it's a formality that has to be done. But we will say in the fee agreement, the retainer is 0, but this is what our panel rate is for your specific carrier, that kind of thing. Does that help?
I'm also really compelled to ask you about sufficient note-taking.
Well, we're gonna have to get into that in another session time, if you all want that, because I've messed up today with court, and I apologize for that, but we're gonna have to get into, because we have a full presentation on that. And we have PowerPoint, all that stuff, and we'll walk you through that. But that's your vulnerability. If DORA, DORA is really adversarial. It's a shame that it's become this way in the state, but it has. It used to come alongside therapists. When Amos ran it for 18 years, it was run very, very well. And we miss Amos dearly. We really do. But today you've got program directors who are politically appointed, and these boards have become punitive, and they're very enforcement oriented. So you've got to know what you're dealing with. What I want is, if you use simple practice, their forms or Theranos or whatever, Theraguide or whatever, their national forms like HIPAA and stuff are really pretty good. But the Colorado specific form you want is your disclosure statement. That embodies your defense, because whatever you disclose, you can do. And so that's what you want. You want a good disclosure statement, which has got your office policies, all that, and so on. I charge either $750 or $850 for that. We're losing money on it, but the idea is the fact I want you to have the best there is. And so that disclosure statement is your primary defense. And DORA will often ask for it. You will sometimes get a subpoena in a matter where they ask for your client files. They're asking for personnel records now, people. We're fighting them on that and that kind of thing. Anything else?
I have a question, please. what would be the cases where you had to defend a colleague? What is the most common reasons that, you know?
Boundary violations. We have moved from a world of where, for example, you in the 80s and the 90s, you could take a client to lunch, you could go to dinner, you could do things like that. All that's out. And now you're stuck to your session, and your note taking needs to be done pretty close to when that session is done. You can do your notes in handwriting. We've gone back to the, after 15 years, we've gone back to the progress notes versus process note standard. You all know this. Progress notes are your session notes. This is what we did in session. Your process notes are your work product, and that is confidential. So that is that's like, where do I think, what do I think about this client? Where do I think we're going? Now you can call them clients or patients, it doesn't matter. DORA can't make its mind up. So you can call them either way. But where are we going? What is the plan for the future? What do I think? That kind of thing. And that's your process notes, which are your work product. There are two philosophies about that. As you open your file, your progress notes, which are subject to any subpoena, or to your client. Remember, when you get a request from a client for session notes, try to have the client come in and talk about what therapy you gave first. If they won't do that, try to do a treatment summary. But if they have a Social Security claim or something else, their lawyer is going to want all their notes. And if they have an automobile accident, they want all the notes. Those progress notes should be in the right side of your file, for example. Your process notes would be in the left side of the file, because you'll get a subpoena, and that subpoena will say produce everything. Well, your process notes are your work product, they're you. So we're not going to produce that. Some of our therapists maintain two files per client, with one having the progress notes, so they can testify honestly, I gave you everything that I had, and here it is. And they keep their process notes separate and distinct. Now, when you deal with your law firm, you can tell your law firm everything. You're entitled to tell me everything. You have an attorney-client privilege with us, and so the client identities, children, whatever, whatnot, HIPAA does, we are exempt from HIPAA. So the deal is the fact, as your lawyers, you can tell us everything. But naturally, what we're going to tell DORA or tell the lawyers, when I file, if you get a subpoena or whatnot, or a demand for notes or whatever, there are 4 categories we comply with. I can get into that later, should we have time. But the idea is the fact we're gonna put guardrails around you, so you don't stray too far into trouble. What is your biggest problem? And okay, so we talked about boundaries. I'm going to go to the courts here for a moment. Boundaries is a big one. Dual relationships is another big one. These are current hot buttons. The failure to report child abuse is a huge thing. Sex with a client, you all know the rules on that. That is a crime in the state of Colorado. The idea is the fact if it's sex during therapy, that's a crime, punishable. We probably defend 100 of these per year. Revocation or the loss of the right to practice is mandatory in those cases. We always lose those cases. And then your insurance company will have an exclusion that they will not provide coverage should you have sex with a client? This is the problem. The Colorado statute goes for 2 years after therapy terminates. And when you terminate therapy, you want to send a letter out or an email out. I'm using a letter in old-fashioned terms, but an email out that starts the clock for 2 years. When you, in Colorado, that person is a client for 2 years. That gives rise to the criminal charge, even after therapy is terminated. But if you have a relation with a client, if you go out to dinner or you do anything, that's a boundaries. If you have sex with a client in any form, that's a crime. DORA will go after that for 2 years. We came up with this. Amos and I talked at length with the psychotherapy board back when Larry and Harl Haggett, and the woman who wrote the book, Women Who Run with the Wolves, Carissa, and I forget her name. But anyway, we used to go to Amos's house for a fire, and we'd sit around and talk about where this all ought to go. And the reason was, when you have sex with a client or relations with a client, and you break that up, they always threaten a grievance. And we have had to protect our therapists. And I moved one therapist around the state, and Dora finally figured out that I was moving my therapist around state to state, how to really protect her from this. But they will try to blackmail you. The real problem with sex with a client is not the power differential, that's the public policy argument, that you have more power than the client. That's what they'll legally say before DORA or in court. But the real reason came up with this was that we didn't want you blackmailed. Now, the national standard, ethically, is you never have sex with a client. But Colorado has gone to the 2-year rule. Colorado decided years ago to be different than the rest of the country. And the problem is, you've got DORA, which is enforcement oriented. The failure to report child abuse is another hot button topic. Elder abuse has not come in yet, but it's there. The imminent risk deal, the police will enforce you. Don't forget, you're a mandated reporter 24/7. So the idea is you've got between 24 and 48 hours to report a threat to a child or the child in danger. Beyond that, we have a difficult time protecting you. You can be prosecuted for the failure to report. This state is so enforcement oriented and is so tied up in what you can document that it's getting more and more dangerous to practice. And you're the tip of the spear. I believe that our psychotherapists have a lot to offer. You've got a lot of compassion, a lot of experience, and I don't take the social work view at all because you have a lot to offer. But it is perilous. You've got to be careful how you proceed. So boundaries, child abuse, dual relationships. There's confusion about that. Dual relationships are, saying the obvious, are typically, if you paint my house, I will give you therapy. Well, that's dual relationship kind of thing. We've seen everything here. I mean, we see really crazy stuff. So through my eyeglasses, I view the world as, you're talking to me, and I'm always going to err on the side of extra caution. So that happens. Okay, other questions? Have I given you all a heart attack yet? I'm so sorry. I don't want to do that. But I want you to know the truth, and I want you to know where you stand. And if you know the truth, then you can deal with it. You know, we're not gonna sugarcoat this. You are in a heavily enforcement state. Forbes magazine rated Colorado one of the top 3 enforcement states. I mean, I think we're number 1. I've been all over California. We're ahead of California. I've had clients in New York. I think we're ahead of New York. It's California, New York, Indiana, Illinois. Florida spells out some pretty good rules for you, some pretty good guidance. But these are heavy hitting states. Colorado is right at the top of the list for you. And what we're lacking out of DORA is the fact that you're not getting the guidance you need. It used to be under Amos that if we needed direction from DORA, we would pay a fee of $60 to $90, and then it became $90. And we'd get an opinion back in 30 days. DORA has not done an opinion for 9 years. That kind of thing. Now, teletherapy is here to stay, and it's here, and it's going, and it's there's no doubt about it. That kind of thing. Your danger is with teletherapy is crossing state lines. If you're in Colorado and you're treating people in Colorado, you're safe. If you go outside the state of Colorado, Wyoming and Washington, for example, consider that to be a crime. So I recently had a therapist who had a Colorado client who was traveling through Washington, and the client called to check in, and the therapist had 2 telephone conversations in less than 14 days. The state of Washington charged the therapist with a crime. We got him out of that. But Washington said, Bob, the first time it's a misdemeanor, the second time it's a felony. But we got the guy out of it. So these states are getting more and more restrictive. Why? They want you to be compliant with their state law. That's the rationale behind it. Other questions?
How did that conversation get reported?
The wife of the client reported it to Colorado's DORA, who informed the state of Washington. That's what the DORAs do. They talk to one another. They meet twice a year officially, and they talk in between, and that's how they got it reported.
So I have a question about. Go ahead.
Sorry. The wife did not like the guidance that the therapist was given. That's the reason she reported. Yes, go ahead.
So what if people present themselves as coaches or mental health professionals
Yes,
and are working across state lines, those kinds of things instead?
I wanted to get to that. And coaches is a field that I think you need to seriously consider. Now, this is the deal with coaching. I got a call one Friday night from a DORA person, because they often call me on a Friday night to talk. And I got a call from a DORA person that said, Bob, let me give you a scenario. We can't tell if this is coaching or therapy. And they did the scenario. And I said, well, you're really talking about my client so-and-so, aren't you? And they said, yes. And I said, well, if you don't know what coaching is, how do you expect my client to know? That was the end of that grievance. Our difficulty with coaching is, as we go state to state, we have a hard time defining it. If you're doing coaching, that coaching practice has to be separate and distinct from your therapeutic practice. You can never go from coaching to therapy and back to coaching. That's prohibited. Because once they're a therapeutic client, that's it. That's where they are. Coaching, I want you to have a certification. We have a whole set of coaching forms that we just are revised. They're really quite good. I have to draw a distinction for your defense that that client comes in and signs a coaching disclosure form, does that, signs off, and we have a paragraph that says, what is coaching? And we define it. Now, DORA has not challenged one document we've done. So that helps you. So,
So-
anyway, oh, go ahead.
I was gonna say, I'm a hypnotist. I know some people are being hypno coaches. So
Right.
if you designate yourself as a hypno coach instead of just being a hypnotist or a hypnotherapist, how does that operate differently?
Well, in Colorado, you're okay. But if you go outside of Colorado, I can't predict how that state will take that. They may say that's a form of therapy, whatever. The states are all protecting their own. They're all protecting their own groups. There's a lot of politics behind this. The lobbying groups are really, in these various states, are really very, very active. And they want to protect their own therapeutic community. The idea is if you get a national certification from some agency, we don't have licensure for coaching at all. There is no registration, there is no licensure. So you want a certification, but we want that practice separate and distinct from your therapeutic practice. We want to build up a wall there between the two. Now, you're allowed to say what your credentials are in your coaching practice, but you're going to say, this is not therapy. I am not practicing therapy. Should you need therapy, you need to consult with a trained professional. And you say that. And they sign a coaching disclosure statement, which clearly outlines this as coaching. Because a lot of the states can't tell the difference. Colorado has struggled for years to clarify coaching as opposed to therapy, and has really had a hard time with that. But if you get a certification, what is really brilliant but costly is if you go to DU or you go to Metro State, they've got coaching programs. And you go through one of their programs, and I'm sure they've got good forms and stuff, and you come out of there, wow, that looks great. What am I talking about? I'm talking about optics. You know what the difference between coaching and therapy is. One of my cases, DORA sent a mark in, and they will do this, and the mark was wired. And our therapist said, if I take off my coaching hat and I put my therapist hat on, this is what I would tell you. And he got a letter of admonition. DORA, there's one investigator over at DORA who will surf websites. Denise Wells does this. She surfs websites. She loves this. So you've got to make sure that there's a clear distinction in your website or in your communications between your therapeutic practice. In a perfect world, but this is cumbersome for you, I would like a separate LLC for coaching where all your client funds go to the separate LLC. If you combine your finances with your therapeutic practice, I want two books. I want the bank accounts to be reflected separately. I'm talking books in old-fashioned term, but I'm from that generation. I'm a paper guy. But anyway, we want to be able to document the separation between coaching and therapy. That's saying the obvious. but you really gotta do that. Now, coaching can make big bucks. It is highly profitable if you in turn have the proper certifications. You want at least some national certification. If you take a coaching course, we use that for your defense. Because what are the grievances? Either DORA finds out about you and the board decides to take action on, which it can on its own. Or one of your competitors, this is the problem in Boulder, we really have this problem. The competitors are turning in other therapists and they want to get there, and if they check that therapist web, I'm sorry to say things like this, but this is the world we're in. They will want your coaching practice, and they check your website out, and it looks pretty good. And they want that, and they will often flip you in for doing therapy. We have to defend against that. We say, no, you were a coach. How do we do that? Separation of finances, separation of roles. Remember, as a coach, you're dealing with tools. You would, if I would come to you, you would say, Bob, these are tools we can give you for your toolbox and for you to be a better lawyer. If I start talking about my mother and the issues that I've had with her or with you, you're a therapist.
Mm.
It's all gray. If you move out of state, now nationally, we haven't seen much pushback yet. I have not had a lot of cases out of state with our people getting in trouble for being coaches. For being therapists and you're out of state, yes, you got to be extremely careful. You've got to comply with that state's laws. But if you're a coach, we've seen a lot of flexibility. What's my hesitation? What do I worry about? I worry about the fact, will that state say you're a coach or a therapist? That's what I worry about.
So if I were to do a hypno coach where I'm doing hypnosis, as long as if I'm not talking about family issues, I mean, but that's okay.
That as an example.
Okay.
If it walks like a duck, it's a duck. The problem is we don't know how ducks walk when it comes to the coaching world. It's not clear. So that's why every document they sign, I want it to be absolutely clear that they are a coaching client and not a therapist client.
Got it.
So you want to do that. And I want you to have a certification that says I'm a certified coach by so-and-so.
Yeah. I've got the education, I just don't have the certification.
Well, get the certification because you want it. It's optics. Does it really mean anything? It's going to cost you some money, but it's optics, because a lot of this world of coaching is optics. We have to show the regulators, this is how the practice goes. We have to show the regulators that you're a real coach. It's not therapy. Now, don't forget that psychotherapy is an umbrella over the entire practice you do. We're carving out exceptions to it. A spiritual minister is an exception to it. And we have spiritual ministers who range everywhere from being your priest or your pastor to a religious group with a sincerely held religious belief. You know, there's a spectrum there. And when I have to defend my pastors or the priests, well, that's easy. If I have to defend a group, but what I'm saying is the burden shifts to you to show that it is not psychotherapy, but it's an exception to the umbrella. So spiritual ministry is one exception, coaching is another, hypnotherapy is another. So you've got to demonstrate these exceptions, it falls on you to prove it. That's where your paperwork comes in.
Got it.
That make sense?
Yeah,
Do you see where we've moved from? You entered this profession to help people. You are highly intuitive. You have gifts I don't have. I don't have the patience. I'm an advocate. I'm out there trying to protect your backside. That's my job. I don't have the patience to, boy, wow, it would kill me to do what you all do. But I mean, the idea is we've moved from that to being a highly regulated state. And it always happens, they pass these rules and these laws for the public good and they forget about the damage done. One question up there and I can't hear you.
you have to open your mic, Maria.
I just want to say that because it's heavy regulated, what is missing is that if our patient travels to a different state for personal reasons and he needs the support, we are being punished because for us, what matters is the well-being, the mental health of our patient that might be facing a family situation and needs to travel. In all other countries, you have your license, you are allowed to work any place in that country, which makes sense, right? Because the standards are the same everywhere. And what's going on here, it's very concerning because what we are missing, because regulation is so important, is the well-being of our patients. When they need us the most, we cannot be there, right? So it's just something to think about in terms of DORA and maybe the future of the mental health profession, where regulation comes first and the well-being of people, it's not as important.
You're the tip of the spear. You're out there doing things because this country and people, do you realize how much, I'm saying the obvious, do you realize how much stress has been put on you? And now you've got the regulators in turn stepping in the middle of it. And they keep cranking out rules that are not published. We hear about this stuff because we deal with all the different boards. So we hear about this stuff so we can tell the trends. But without that, you don't know what's going on. So there you go. Now, generally 10 days is the informal limit when that person goes out of state that you can deal with them. Beyond 10 days, you're at high risk.
Thank you for that.
That's a formal rule. All right, I apologize again for starting late today. It's now 12:30. Did you find, was this at all helpful or was it more terrifying? Was it more Halloween than helping you guys?
Well, it was helpful to me, so I really
Yes.
appreciate your time.
Very informative. Thank you for your time. We really appreciate that. And maybe we can think if in the next year, the presentation you have about notes and something that is very specific for all of us could be, I think, a good idea if you or anyone in your law firm is willing to do that. Okay.
Sure. We enjoy this and it gets me away from court and I love this stuff and I just want you safe and the law firm wants that too. So if you guys want more involvement from us, let us know. And because it's I don't want you out there on your own. And so let us know, okay? And we're happy to help. You all have a great day.
Thank you.
Thank you.
All right, take care, everybody.
Thank you so much.
Take care.
Bye.